So now to kick us off and introduce our guests, I'll hand things over to Patrick Dunleavy, newly elected ARA board member and the chair of the newly formed ARA Contracts Committee. So Patrick, the floor is yours.
All right. Yeah. Thank you, Tony. Hello, everybody. And thank you for taking the time out of your busy schedules to hear what we have to say today. As Tony mentioned, my name is Patrick Dunleavy, a newly formed committee chair of the Contract and Insurance Committee. Today, presenting with me, we have Mike Poplinski and Patrick Newman. They are both our committee members here. We also have Bob Stankovich and Chris Turot as members as well. So our ARA membership has spoken. Our agent community really has spoken, and we've taken note and we've listened, and we've formed this committee on your behalf, which ultimately will provide a valuable member benefit that, in our opinion, has been really long overdue. Today, we're going to discuss our committee intentions, our goals, and also shed some light on a few important topics that we feel our members should really be well educated in. So our objectives are listed, outlined here below. We're looking to establish industry standard contract norms. So, some of these agent members that we have, maybe they're not as familiar with contracts and what they should look like. We intend to really provide a standard contract, that the membership base can utilize when needed. We are looking to work with our clients and hold our clients accountable for some of the contracts that are really affecting our membership, and negative and highlight those things. We're going to initiate those challenging discussions about some existing contracts, and look to work with our client partners, to work through those challenges. Provide recommendations to our membership base for revisions to ensure that our members are protected. Ultimately, that's really important, and you need to make sure that you're protected in your contracts as well as in your insurance. We're going to talk a lot more about that with Patrick and Mike. Clarify liability parameters. This is a really key piece, to this whole process that oftentimes gets overlooked. And again, we're going to really dive into that later in today's call. So our primary goal, is to proactively address current contracts that are in place, while setting new benchmarks, new standards, and contract language to really protect our members. So, really breaking each bullet point down, establishing industry contract norms, what does that mean, right? So we're looking to define and promote best practices in contract drafting and execution. What are key things that should be in there, and what's the best way to go about executing it? An executed contract is not a contract at all, right? So identify common pitfalls and risks in contracts within our client sector, and really make those things aware to our membership base, and just provide that education. Develop guidelines for creating contracts that prioritize member protection and clarity. I just want to stop and reiterate and emphasize, member protection and clarity, right? Develop standard contract template to share with their agent community. If you get these one-off clients that are reaching out and they might have an account to send your way, it's really important that you have a contract and all the verbiage in place with that client to make sure that that repo is protected. And oftentimes, the handshake deal, doesn't protect you, and so it's really important that you put those things in place. It's an extra step. It takes extra time, and some people don't necessarily have the resources to do that. But this committee is here for you, the members, to help provide that resource. We're going to create accountability for contracts that affect our membership. Reviewing all the contracts that impact our association members. And this, I want to just highlight, includes attorney review. So, how that process is outlined and how we plan to make that work is we're going to provide an email address at the end of this presentation. And any questions that you have pertaining to a contract, insurance related questions, we're going to funnel that right to the email inbox of this committee. And then, the committee is going to review those things and provide feedback, to you as the member. We're going to hold our clients accountable for adhering to agreed upon contract standards, right? That's important. The wording is in there for a reason. And so, need to make sure that, people, are accountable for that. Initiate discussions on existing contracts, right? So a lot of you have probably signed contracts that you don't even know what's in the contract. And I'm probably guilty of it too. But this committee is going to help identify contracts that may require revision, or clarification on things. We're going to facilitate those discussions with our memberships, clients and agents, and bring those concerns to light. We're going to determine the effectiveness of current contracts in meeting member needs and priorities. So really take a look and make sure that it's not a one-sided contract, and it's really meeting priorities of both parties. We're going to recommend revisions for member protection, propose amendments or updates to existing contracts to enhance member protection. That's the second or third time that I've said that, and we're really taking a strong stance on protecting our members, right? And speaking primarily to our agent members, but also our client members, because the clients are partners too. And at the end of the day, the contracts should be there to protect both of us as well as insurance. Collaborate with legal experts to ensure that contract revisions comply with laws and regulations. Again, we are going to utilize Patrick Newman's services, and he's going to really help us out in a lot of those areas. Mike Poplinski has been a huge advocate, great resource and subject matter expert for a lot of the insurance piece and portion of contracts. However, together, teaming up along with the rest of the committee members, we're really strengthening that resource for our membership, because we recognize how important it is in today's world. We're going to clarify liability parameters, and this is really important. Patrick and Mike are really going to get into this later in the discussion. Defining clear and concise liability clauses within the contracts. We're going to educate members and stakeholders on their rights and responsibilities under contract agreements, and really mitigate potential legal disputes by establishing transparent liability parameters up front. I just want to take a moment, let that sink in. That's a really important line right there. And again, Patrick is going to speak to that, and how crucial that is later on. Proactively address current contract dynamics, stay informed about industry trends and regulatory changes affecting contracts, working with Repo Alliance, finding out what's new, what's coming down the pipeline, the CFPB, how is that all affecting our industry? And, are those contracts up to date, for those rules and regulations that are constantly changing? Anticipate potential challenges or emerging issues on contract negotiations. Yeah, there's going to be difficult conversations to have, and we'll help identify where those challenging key points are, and come up with key talking points on how we're going to get through those challenges together, with our client partners. Continually assess and update contract norms to adapt to evolving business environments, right? It's not 1970 anymore. It's not 1980 anymore. There's technology that comes into play. There's AI, there's all these different things that are constantly changing in the world. And so our contracts should be updated and changing, with that fluidity. Set new benchmarks in contract language. Innovate contract language to reflect best practices and emerging standards. incorporate feedback from members and stakeholders to improve contract readability and effectiveness. There's many times where I read a contract and I'm thinking to myself, what the heck does this even mean, right? Having a viable resource such as this committee to reach out to and say, hey, guys, what the heck are they talking about? Is this something that I should really pay attention to? Or, is this, sorry, Patrick, is this just attorney, mumbo jumbo that's in here, right? We're going to help guide you through those dark spots on the contract and really shed some light on those things. Establish our association as a leader in setting high standards for contract integrity for our members, right? I think that's important. This is a resource that, we're bringing to the table. We have subject matter experts in all areas. And, we want to provide this service, this benefit package to our membership. And it only works if we have participation from our members. So, we want to hear what you have to say. Don't hesitate to reach out. The questions that aren't asked are not answered, right? So please, I encourage you to reach out to us and use our services. So, at the end of the day, I mean, do you know what your contract details really mean? Are you guilty of signing contracts without reading through the entire contract? I am, I've done it. We're all busy, we're running businesses. And, if I'm being completely honest with you, contracts and insurance, probably on the bottom of my list for favorite things to do in my business. But, I think this is a great opportunity to get educated. We're going to learn together with all the resources that we have, and ultimately, protect our membership, protect your businesses, and, make sure that you're staying educated on these ever-changing topics. So, that's what I got here. Now we're going to get into, the whys, right? Why do we have to worry about all these things? Mike and Patrick are going to go back and forth in a dynamic here to share some of those things that you might be shocked to find out. So I'll turn it over to you guys, and thank you.
Thanks, Patrick. Appreciate it. Before we get into the data, one thing that we want to stress is everything goes back to the contract. You heard us say this a million times, but more now than ever, it all goes back to the contract. Why? Well, let's look at the data, right? I love crunching data. I love, looking at trends. I love looking at where are things going? Why are they going there? So, last 3 years, the lawsuits that we have coming through our door, right? Almost 1 out of every 2, almost half, 49%, I consider invalid assignment, which is what? They're paid up to date, lien loss, whether it's military leave, something that really has nothing to do with the recovery agent. It's all the due diligence upfront that you guys aren't part of, all right? So what's that tell me? Well, one, if we don't have proper contracts in place for you and your lender, forwarder, finance company, then you're going to be stuck, right? It's nothing that, as an insurance agent, we want everybody covered. We want the lender covered when they're supposed to be, the forwarder covered when they're supposed to be, you guys covered when they're supposed to be. Problem going on right now is contracts are, let's be honest, about 80% of them that we see come across our door are missing contract language that helps you, that protects you. And what happens right now is these lenders, forwarders, for the majority, and not everybody, but majority, are just offloading all their liability onto you. And a lot of it comes down to, or all of it, I should say, comes down to the contract. And it's not that, hey, they'll take care of me. If something happens, we got your back. That's all great. It has to be in the contract, it has to be in writing. Claims by the numbers since 2015. I mean, honestly, early 10 plus years ago, wrongful repossession was just kind of gravy in terms of the insurance premium. It was kind of helping offset auto liability claims, right? Right now, that's not the case. We're seeing more claims now than ever. Over the last 4 years, every single year has been increased by over 30% year over year over year over year. So what's that telling you? Well, one, we always want to be compliant. We always want to learn properly how to handle situations. But regardless of what you do, how perfect you can be, lawsuits are coming for many different reasons, right? So you have to have your contracts in place, properly written. So when it does come, listen, if it's your fault, we're on it. If it's not, they should take care of you, right? And that's really happening at a very small rate, too small to really accept as an insurance agent, as an insurance provider, because insurance we know is too expensive and very, very challenging to get. You guys have probably heard all these numbers. Back in 2016, we had 7 to 10 carriers, depending on your state, that play in your space. Now we're at like 2 to 3 carriers that play in your space, depending on the carrier. Why? It's not because they're making so much money that they thought they made too much. It's they can't get their arms around the losses. They can't charge the appropriate premium to get their arms around their losses to make sense. So they said, we're out, we're done. We're just walking. So the few carriers that are left, well, hey, we need to protect them just like we want to protect you. And we want to protect every lender, every finance company, forwarder out there that's supposed to be. That's, just looking at these numbers, that's what it's telling me. I'm going to throw it to Patrick Newman really quick. Patrick, in your experience dealing with this as an attorney side, how are you looking at these assignments that are coming through, that lawsuits that you're handling?
Yeah, thank you, Mike, and thank you, Patrick Dunleavy, for the introduction and just the ability to come and talk with everybody. I'm with Bassford Remley over in Minneapolis. I have to lawyer you all briefly just to let you know that, maybe someday I'll be your lawyer, but today I'm not. So I'm not giving anybody legal advice. And I also have to be careful not to give anybody an insurance coverage opinion, because we actually do. Our firm has a relationship with a couple of the carriers that write the risk for the industry. True Stage is kind of I don't know if the new kid on the block is the right way to put it, but we've done a lot of work with them over the years. And so we just don't get into coverage issues because we do defense of these claims. But yes, we've also noticed, Mike, the uptick in these lawsuits, and Minnesota in particular has a really long history of the wrongful repossession claim. A lot of the law has been developed here, and I don't know why. There's a particular law firm that I won't name that you probably all know that brings a lot of those claims. So perhaps that's what it is. But yeah, we see this this split in the allegations between breach of peace or some kind of noticing issue. And to the point that Patrick Dunleavy made earlier about understanding the risk up front, transparency and mitigation, you do have to understand these contracts as a playbook for how things are going to go. I had a law school professor who once told me, there never is a problem until there is one. And it's kind of a stupid thing to say, but it also makes some sense in an odd way. And that's really what your contract is once this goes south, whose responsibility is what? And you've heard that, I'm sure, from us. And, another thing, I'll just say this. Everybody on this call is a sophisticated business owner. I think your industry doesn't get enough credit for that. You all deal with so many contracts in your day-to-day lives that you probably understand a lot of these things. But if you haven't seen one where it got really kind of messy in a lawsuit, I'll just give you this little tidbit to think about. Let's say you're sued as an agency along with a forwarder and a lien holder. So there's 3 defendants. You're all in the pool. Nobody's happy to be here. And sort of the worst thing that can happen for everybody on the defense side is if you get into a public fight about who's responsible for what. Because now you're just putting blood in the water for the sharks on the plaintiff side. They love nothing more than to be able to drive a wedge between you all, so there's infighting, and then they can capitalize on that. So to the extent that you can have a united front, that's just better for you from a defense perspective. And the best way to get there is to have a very clear understanding in your playbook about who's supposed to do what. And so that just starts with making sure that you have an understanding of the contracts that you're entering into and what risks are assigned to whom. And by and large, they can say whatever the parties agree to. So, Patrick mentioned, and by the way, I'm guilty of that also. I'm a lawyer and I've signed contracts without digging into them. In fact, my first thing that I did, the first really annoying thing I did after my first day of law school, I needed a new cell phone, and I went with my now wife to like the T-Mobile store or whatever, and I read the terms. I read the terms before I signed it. There was a line behind me before I would agree to it. I was not a popular man that day. But anyway, I'm guilty of it too. You got to know what you're signing up for and what's required of you. And so knowledge is power in that regard. So yeah, and I was talking to Patrick and Mike in preparation for this webinar. You all know this too. Anyone can allege anything in a lawsuit. Whether or not it's true is another question. But you have to be prepared for sort of the worst case scenario, allegations of some kind of confrontation between the agent and the borrower, plus there was no right of possession to begin with because of, like Mike was saying, a payment arrangement or a cure had happened that was not communicated, such that it's going to drag everybody in to the litigation. And if your contracts are drafted clearly enough, everyone will sort of know their role and responsibility such that we don't have to get into an argument in that regard if the lawsuit does come. And this is, well, I can save my compliance plug for as we go along. But yeah, Mike, we're seeing a lot more of these cases locally and nationally. So yeah, I can put truth to that data from my experience.
Patrick, Dunleavy, can you flip next slide, please? So really why now, as Patrick Newman was saying, the volume's increasing. It's really kind of pointing fingers of who's responsible, who's not. And that's been kind of a battle that everybody's been fighting for 5+ years. All this increase, a lot of it has nothing to do with you. A lot of it's just this attorney advertising you've always heard. You all heard a lot. The public is getting educated more to sue. These contracts have been in place for years, which is causing what? Well, they've been in place for years, same language. Everything's kind of, getting offloaded onto you guys. You can flip the next slide. So we talk a lot about this, the most dangerous phrase in the language. We've always done it this way. And I was just on the phone with a forwarder last week, and they literally said, we've been doing it this way for so many years. It's never been an issue. Why now? Right. And to me, really, there's honestly not much more that's irritating than something like that of, listen, times have changed. Why did it work 5-10+ years ago? Because it wasn't an issue, because nothing was getting brought to light. No one was, getting hurt by it, right? There wasn't claims that were challenging you guys to even get insurance. Right now getting insurance is an accomplishment in itself. We have to adapt to times. Lawsuits are a thing kind of in every industry, specifically ours, with these lawsuits coming for wrongful repossession claims. And if you don't have it right, it's going to end up on you. And right now it is ending up on you. You can flip to the next slide.
Can I just
Thanks,
say,
Patrick.
Mike, to your
Go
point, that always done this way, a follow-on to that is consistency of your different contracts. I would venture to say that the average repossession agency probably has 5 to 10 vendor agreements through different forwarders and lien holders, at least, if not more. And I'm sure you have them with your different service providers you're paying them, and just not even reviewing for just the new times and the new environment that we're operating in, but bringing them all out and looking to say, are these consistent? Have I promised one party I'm going to do or not do something and then told another party that I've contracted with the opposite? I mean, you could be signing contracts that you're already in breach of on day one if you're not actually looking at them and comparing them to one another. And I, again, not an insurance guy, but I do think that has, you're probably well served to be thinking about your service agreements in comparison to your insurance policies as well, to make sure that there's consistency and you're complying with both.
Perfect. This slide, spend a second, talk about the playbook. Your contract is your playbook. A lot of claims are being denied, and I want to spend a lot of time more so on that, based on your playbook, which is your contracts. A lot of them are undesired outcomes for you. A lot of them, because we're reactive and trying to figure it out after the lawsuit comes in, you guys are getting stuck of, hey, that shouldn't be paid. All right, you're right. We are denying it. It didn't trigger coverage. We're going to deny it. But then you're stuck. Well, now my lender's not happy and they're going to cut me off if I don't pay it. So can you pay it now, or do I have to pay it? It's just undesired outcomes. And if it's done upfront proactively, then these outcomes are going to be the desired outcomes that you guys want. So you can flip, and we'll kind of get into really why our playbooks are failing, right? Starting off, number one, language in your contract. So first off, who's writing the contracts? Well, it's the lender, the forwarder, the finance company. They're dictating all of it, and that's fine, but you have to have a say in it, right? It's a two-way agreement. And many of it, they don't understand just as much as you don't understand some language, some verbiage that changes the outcome completely. A lot of it that we've been pushing on is the additional insured status. This is probably the number one reason why coverage is not getting extended to your partner, which is your lender forwarder. This is literally the number one reason in probably the last 6 to 12 months, as so much frustration is going on with the forwarders, the lenders, you guys as recovery agents. If the additional insured status is not requested properly, it is not granted. Now, most everybody that at least works with me, but majority of everybody, regardless of the carrier opting, has a blanket additional insured. Majority of carriers, right? When I say majority, there's only a couple, but all that means is it's automatically given if in written contract, if properly written in your contract, right? If it's not in the contract, well, guess what? It's not given, right? And for a forwarder, and this is a big one for the forwarder, they're 74% of the assignments that are put out into this industry are coming from forwarders. They're requesting themselves, all right, so really listen, they're requesting themselves to be additional insured. They are not requesting the lender. So what happens when a lawsuit comes in, nobody knows about the middleman, right? So the lender, XYZ Bank is named and XYZ Recovery Agent is named. No middleman. So what happens? That bank needs to be covered. So they go to the forwarder and say, hey, you got to cover me. The forwarder then in turn goes to the recovery agent. Hey, you have to indemnify me and you got to cover me. And then they turn to us and we'll say, all right, give me your contract. We do not say, send me your certificate of insurance. We say, give me your contract. And most of the time, unfortunately, right now, the middleman, the forwarder is requesting themselves and not their clients. So as simple as XYZ forwarding company and our clients, those simple words, and our clients, that's the trigger, right? So you're going to be covered as a recovery agent. However, the lender will not be covered. Okay. That is the biggest problem going on right now. And I've had a lot of conversations with people saying we're additional insured. We put it in our contract. And if you go to that third bullet point here, indemnification is not an insurance obligation. So what does that mean? Well, there's an indemnification section on your contract. A lot of forwarders, a lot of lenders are putting in their section of the indemnification saying, you are going to make me whole. If you did anything wrong, you're going to cover me. In small words right there. That has nothing to do with an insurance obligation. That is a contract between you, the recovery agent, and the lender forwarder. If they want to be an additional insured, it has to be outside that indemnification section and in the insurance area. That is a big, big area, a misconception really, of what is going on with denied claims. Patrick Newman, I'll throw that part before we move on. The additional insured status, kind of get your take on it, to get your take on the contracts with how it's written on that piece.
Yeah, no, I appreciate your comments, Mike, and I think you're spot on. Is the difference between an insurance obligation and a contractual obligation? I mean, they're two separate contracts, right? I mean, that's what an insurance policy is. It's a contract between you and your insurance carrier. And unless it's kind of what I was saying before, unless they fit hand in glove, you're setting yourself up for a bad surprise later. which is why anytime you're getting a new service agreement with whether it be a forwarder or a lender directly, whomever, is making sure it's consistent, that you are meeting the obligations. Here's an easy one. Most of them have a minimum insurance coverage requirement. So that's easy. You should already be comparing that provision of every agreement to what your insurance coverage is under your policy. And considering, like you say, who needs to, if there is a need for an additional insured, do I have that? Because that's the variable you can control, is what these contracts say and cover, and you can understand them. I know you don't always get what you want in these negotiations, but you can at least understand what's going to happen. What you don't get to pick is who sues you and how they do it. Because like you were talking about before, Mike, the way that the tender, that little up the chain, down the chain relationship unfolds, that's outside of your control. You can't fix that. And you can't fix the fact that eventually you can expect to be sued, just given the volume. So, but it is in your hands to understand the relationship between your policy and your service agreements. So just comparing them, even if you say, hey, other party, whether it be a lender or a forwarder, whomever, say, hey, I want it to say this. And even if you don't get what you want, at least you're living life as a business owner knowing what your risk is. If you don't even know what the risk is, there's nothing you can do to mitigate it. You're just kind of lost in the woods. So, again, it's an old phrase, but knowledge is power in this context, big time.
I see as many additional insured requests written incorrectly as I see not even requested, period. And that's where you guys, as a recovery agent, can kind of be a good partner to your lender or forwarder and saying, hey, we need to get this in place so you are covered if and when something happens. And again, not to get into specifics, but a lot of this stuff is, no matter how perfect you might have been, you can't control, as Patrick Newman said, who sues you and why, right? You can't say, I didn't do that, you can't sue me. We all know that. So we need to get this language, this verbiage in play, properly written to cover both parties, so everybody's happy when it comes. No one's trying to skirt around getting out of anything. Goes back to the contract, and if it's written properly, then you're good. If something comes at you, you're good. Now, if you can flip to the next slide, I do want to touch on this piece and then get Patrick Newman's piece on it. The last bullet point, coverage does not apply. So one misconception is, hey, you buy insurance from whoever, and I am covered. No matter what I do, I am covered. Well, no, there does have to be something to trigger coverage, right? And there are exclusions to your policies. Assault and battery is one of them. Now, there's so many attorneys throwing lawsuits all over the place. They're not very good anymore at crafting it to get the insurance carrier involved. We've had plenty that, for example, will just sue for assault and battery. That's it. And that does not trigger coverage because in your policies, there is an exclusion for assault and battery. There is an exclusion for firearms. And I know that's a hot topic because of, many deaths that we've seen in our industry, just as we had one the other day. Yes, there is an exclusion for firearms. There's an exclusion for assault and battery. It only takes one accusation to trigger coverage, and then we go. However, if there's nothing covered or nothing to trigger coverage, we don't just pick you up because you're our buddy, right? Patrick Newman, I want to see kind of get your take on coverage does not apply.
Yeah, this is another instance of appreciating and understanding just exactly what your policy says. What are the circumstances that will and won't work for you? It's a bit like your homeowner's policy. If you own your home, it's nice to know what does or doesn't apply, or your auto for your own personal. I'm not sure that it dictates the way that I drive my car, but it's nice to know whether I have complete coverage or if it's just liability coverage. Again, just knowing what your exposure is, because it's an unfortunate and uncomfortable conversation, I will tell you, in the defense of these lawsuits, where I have to tell a client that, hey, this is maybe a bet the company problem for you because of what they're going to demand. And if the carrier has said, hey, no dice, this one isn't covered, well, it could be a large chunk of change to try to get a case settled, or to even just to defend to a point where we can get it settled at a reasonable figure. So it's a money problem, unfortunately, at bottom. So knowing whether you're likely to have coverage or not is a big deal. And for what? And you mentioned the assault and battery exclusion, and not speaking to that directly. And if you spent much time around me, either at NARS or whatever, or on one of these webinars, I will tell you my big compliance sort of challenge to the industry to avoid those types of claims, or to know if you have a problem up front. Because I think a lot of times these things don't actually unfold. This is not shocking to anybody on this call, but they don't actually unfold in the way that they're alleged. A borrower says that the agent pushed them or screamed at them or refused to put the car down despite the protest. And I think a lot of times that's not true. And so the problem comes down to, well, the borrower says one thing and the agent says another thing. And from a legal perspective, do you know what that means? That's a guaranteed jury trial. That's the only way you're going to get that decided. And that's the most expensive, biggest risk way to resolve a lawsuit. Even if you're right, even if you know and your agent knows in their heart of hearts that this is all lies from the borrower. And so really the big way to combat that is video footage. And I know you all have done a great job of putting them on your trucks, but I would really challenge you all to think about getting body cameras. And you guys maybe have seen some of the publications we've done on this. There is data out there. If you're familiar with, they're called Section 1983 claims against law enforcement officers for excessive force. They face a very similar problem where they get these allegations that they beat up a suspect. And, of course, this happens from time to time, but in the legal context, when they're sued, turns out a lot of times the plaintiff is not telling the truth. And so where the officer records the incident from the beginning to the end, and that video footage is presented to a court, 80% of the time, 8 out of 10 times, the court dismisses the claim in favor of the law enforcement officer. Think about that. How nice would it be if you got sued on one of those claims and you said, no, Patrick, don't worry. Let me send you a little video file here that I got, okay? And you send me a complete footage of the incident, and I get to send that. That's my favorite email, by the way, as a lawyer, that I get to send. When I get to take the complaint and I get to tell the other lawyer, hey, you might want to have a conversation with your client about this. It's amazing how fast those go away. So the cost of your footage, and I know the hardware is not inexpensive and the storage is expensive, but boy, does that pay off big when you're not paying the bad guys. You're not paying someone like me to defend it. You look great to your insurance carrier because you're compliant and you can demonstrate it. It's just something I think you should all think a lot about. I think the industry would turn a serious corner in combating these baseless claims if you did that. It would be a great arrow for me to have in my quiver. So I don't know if that really directly addresses your point, but
yeah, to further on that conversation about, I'd say, 7 to 10 years ago, we were having these similar type of conversations about cameras in your trucks, and there's a lot of pushback for various reasons from a cost standpoint, all different pushback. Now, majority, there's very few that do not have cameras covering their trucks, and most people that do will say, I won't put a truck on the road until that's equipped with camera footage because how much it saves you. It's almost to the point now where you can't afford not to invest in them because of how much it will save you from these claims. From the insurance standpoint, right? Your claims go down, your premiums are better. And quite honestly, without the hard footage, the he said, she said, you're losing. Right, wrong, and different. That's reality, right? You will lose. And that's the biggest piece that that I can kind of throw in on the body cams, the
Yeah.
volume, the footage on. Without that, you lose. I did
Yeah.
want to throw another question at you. I get it all the time, but I like to hear from you as well, Patrick. Why doesn't the insurance carrier, you represent with your insurance carriers, why don't they just attack these things? Because they know some of them are obviously bogus claims. And if they fight one, that we hear it all the time. If you fight one, you'll set the precedent and they won't come at us anymore.
I think with the right facts, it makes a lot of sense to fight back. But you nailed it right now. The dynamic that's tough for us is evidence, because as a plaintiff's lawyer, you got to remember it's all about leverage. Okay. It's not about the best lawyering. Really, what they're trying to do is create leverage. And the best way for them to do that in a case like these, where remember, 90% of these claims include an allegation under the Fair Debt Collection Practices Act. And the reason that matters is there's what's called a fee shifting provision in that statute. So that means the repossession agent, the defendant, if you don't win, you're paying the bad guy's attorney's fees too. So you're paying two lawyers. So you got to be right, and you got to be 100% right. Otherwise, you're paying the freight for the bad guys. So if I'm a plaintiff's lawyer, all I want to do is create that he said, she said dynamic, because that means this is the most expensive lawsuit for you to defend. I don't need a great claim. I don't even need one that's completely meritorious. I just need one that's going to require a trial. So you guys should be thinking from a compliance standpoint, how do I prove that we did it right? And how can I do that quickly up front? So that's why there's hesitance. I can't speak for a carrier and their decision, but when I get brought on board to look at one of these and to talk about, hey, how should we handle it? If, like you say, it's a total he said, she said, a lot of times my advice is going to be, let's find a way to mitigate our problem and get ourselves out of this in the most economically feasible way. But golly, if I had one that had the evidence that I could use, I would recommend fighting these from time to time, because you do need to establish that you're not going to just roll over every time. But we need good facts to do that. You've maybe heard the phrase "bad facts make bad law." That's true. Okay. So unless I can show compliance, unless I have a good story I can prove to a jury, it's just not a good idea. I wouldn't tell you to go march to the sea and spend a bunch of money only to potentially get your clock cleaned. That's not good for anybody. So, and don't get me wrong, we get cases that are defensible in this space. We do. I just think we would do a lot more defending and a lot more being on offense if we had the goods, if we could actually have an objective way to prove it.
Hey, gentlemen, we are at the 15-minute mark, and we've got quite a few questions queued up. Are we at a point where we can start with that, or?
Absolutely. Absolutely.
All right.
I can look in the Q&A and kind of see the first one. Where does insurance stand as far as covering agent form said false claim, even if there's a trigger? Can you expand on what the agent would expect to happen from an insurance carrier? I'm not exactly understanding the question, but I'll kind of do my best to go off of what I think you're talking about. So if there's a trigger, right? If they have 5-7 allegations, most lawsuits have multiple allegations on them. Only need one to trigger coverage. Once there's triggering coverage, at that point, counsel is assigned, and we start our process, right? And we start our negotiations. And maybe Patrick, you can jump in, in dealing with the negotiations on if there is a triggered coverage form that the insurance is going to step in, where does it go from there, if I'm understanding the question properly, and how do you kind of settle up on a end result?
Yeah, that's going to come down to conversation between insured and carrier about where to go from there. particularly where if I'm defense counsel, I wouldn't enter into those negotiations. I will tell you, I do not work for TrueStage, what used to be known as CUNA, but I've had a good relationship with them. So has our firm for a number of years. And I found them to be pretty straight shooters in how they treat their insureds. The benefit you all have is that they also are aware of some of these statutory issues and sort of the unique challenges that they present. So I would encourage you to have a dialogue with them and with Mike too. I hope you all know what you have in Mike Poplinski. He might be the best educated guy maybe in the world about the intersection of some of these well, I just don't know if there's anyone else quite like you, Mike. And I mean that in the best possible way, of course. It's on these issues between the insurance and the liability questions. You don't have to be a lawyer to understand that dynamic. One thing I do want to amplify, I saw a comment about video footage. Video footage is no good if you don't have it. Okay, so being able to say, well, we did have video, but it's gone now, that's no good. So, and knowing that storage costs are real and they're not cheap, I would really, really challenge you all to keep copies of video, all video, if you can help it, because it's always the unexpected one. It's not the one where you had a super belligerent borrower who ends up suing. It's the one that went completely fine, and then it's a manufactured claim later that has no basis in reality. That's the one that bites you. So I don't think it's a good practice to say, oh, well, I'll just save the ones, that were heated, or we'll flag the one. Don't do that. Just, if you can stomach it, keep it on record. I'd love to tell you 3 years is how long you should keep these things. And you're all going to tell me that's insane, but 2 is better than 1, and 1 year is like the bare minimum that I would recommend. And just because I'm a lawyer and I can't help myself, the availability and like the legality of using body cameras is going to depend on what state you're in. So you got to look at that before you dive headlong into this. But just assuming it is appropriate and okay in your jurisdiction, you should do it.
Going on, next question. Cameras are vital to our industry, absolutely. And the question is, do agents receive any discounts on insurance premiums? So that's a simple question that I've answered many times. Directly, no, and let me tell you why. And I use this kind of, example as kind of the no is, you can send a driver to defensive driving school. They can come out. It doesn't mean they're all of a sudden a good driver, right? They have to take what they learn. They have to implement it. They have to put it in play. And we all hope they become a defensive driver. Just because you go to defensive driving school does not mean you are a good driver. Just because you have cameras, it doesn't mean all of a sudden you're a perfect situation, right? You have to use them. You have to coach with them. You have to put them to work, right? So in theory, yes, your premiums will go down because they will help get you out of claims. They will help minimize all that you're dealing with, right? So your claims will be less, or minimal claims coming at you, and easier to defend. So yes, in the roundabout way, yes, you will get a discount based on your claims going down, but you will not get a direct discount, because I'm not about checking the box. And I know most of you guys aren't either, but checking the box like our industry used to be is kind of gone, right? It's about taking what we have, putting it in play, and doing something with it. And in time, yes, your premiums will come down. Let's see.
Got a
here.
question. This is probably, and forgive me if this has already been addressed, but I think this is geared towards Patrick Newman. How is the committee and or attorney resources complying and navigating NDA expectations in client vendor arrangements when reviewing agreements or providing options or guidance?
I'll ask that the other more educated Patrick correct me if I'm wrong about this, But I understand the scope of the committee to be contracts generally, so not just one particular form or one contractual relationship over another. So I think, if there's a specific recurring issue, I think it's something that the committee would look at. Yeah, that sounds like one that might need a little bit more specifics about the relationship. But I know that NDAs are fairly common in every industry. So as a general matter, I'm not offended by them if they're used for a legitimate purpose. I mean, I think we all have our secret sauce or what have you that we don't want people sharing or using for an improper purpose. But NDAs can overreach. They can be used for a purpose of trying to stifle legitimate discussion, and that's an entirely different matter. So.
Before we go to the next question, I just want to throw, obviously we have the email on the screen. I encourage everybody that has questions, send an email. We will all look at them. We will get back to you in a fair amount of time. And that includes, and I hope everyone hears, that includes every lender forwarder out there that has questions on their own contracts to make sure they're good, or how something will play out, or whatever the question may be. Please reach out. We are looking as a group to partner with everybody, right? We want everybody covered. We want everybody to feel that we're looking out for your best interest. I'm looking out for all my insureds and their clients, right? Because if you guys are all happy, everybody smiles, right? So that's what we're looking for. So I do encourage everyone to utilize that. We will get back to everybody in a very quick time frame.
About the attorney-client privilege, does it extend to these activities from association to members?
I'm really glad that someone asked that. Had I been thinking a little harder, I would have mentioned something along those lines. So I'm a lawyer, don't represent anybody in this context unless unless we had an existing relationship or something like that. So things that you're sending to the ARA, you're not sending those to your attorney. So they're not privileged. So I think it's far better for everybody to just note, that they have a question, and then you can set a phone call to sort of discuss the particulars. And, if ultimately there's a specific review that needs to be done by counsel, you would then exchange that information with an attorney where that privilege and the confidentiality obligations apply. So yeah, I think really that's probably something worth publishing by the ARA with respect to any inboxes where they're going to be taking sort of case by case questions, just so nobody is inadvertently seeking legal advice or sharing things that they don't want to have public. Put it this way, don't put anything in an email to that inbox that you don't want shared with the entire world. It's not that ARA is going to do it, but that's just, like, legally speaking, that could be the outcome.
Now there's another question I wanted to jump on. One of them was using all the collective experience within our agent network, the ARA, myself, Patrick Newman, how can we develop a standard contract that provides clear and fair language? That's a challenge, but definitely something that we would love to go at. It's a challenge because right now, how it stands is every lender forwarder writes their own contract, and you just got to sign off and possibly make a tweak here or there. But collectively, together, we would love to be able to, as a group, get certain areas documented that we need part of all these contracts, and work with every forwarder, every lender out there to make sure that that's implemented, that is a part of every contract that we have. So I think it's a great question. I think it's a goal of all of ours to try to get some sort of standard within these contracts. But the challenge lies is right now every lender writes their own. So we got to work closely with them, and we got to collectively have conversations with them to get on the same page. And as much as we want their liabilities to be covered when it should, we've seen a lot of great demonstrations by lenders, forwarders to kind of return the favor. It's just not 100% right now. And that's what we got to continue to strive for.
And that is part of when I say the knowledge is
Did he freeze us, Patrick Newman? I think we lost him.
Yeah, I think we may have lost him.
Um,
Well, let's Mike, you might be able to address this. When it comes to assault and battery, is that when the debtor assaults a staff member or when an employee assaults a debtor?
So the assault and battery exclusion on all your policies, really regardless of who you're with, it's the same across the board within our insurance. It's when you, the insured, so the owner of the policy, is being sued for assault and battery to the plaintiff. So it's really when any of your employees assault somebody and they're suing you for that.
Sorry, I guess I just had to duck out there for a minute. I don't know what happened. So anyway, yeah. Now just knowing what different provisions look like and how they can be structured, big advantage for you. So hopefully this committee can help just point out some of those issues. But I know we're coming up on the hour, so hey, thank you, Patrick and Mike and the ARA for inviting me. I hope I said something useful that the audience can take home, because these issues are pretty important.
Yeah, and again, I appreciate the opportunity to be on this. My team and I, we love advocating for this space. We believe in this space. We want to partner with you guys, and all we're doing and looking to do is just bring value and assist you guys to get you in a better spot. Because in my eyes, if you're in a better spot, my team is going to be in a better spot. So please lean on us every way where you can. Patrick Newman's an unbelievable resource. Utilize him, and honestly, this committee that Patrick Dunleavy's spearheading is very exciting because I think it's something that we really need.
Yeah, thank you, everybody.
Thanks, guys. Hey, everyone, we'll have this recording and the slide deck up on the ARA website. I'm posting a direct link to where the replays are. So just be on the lookout for that. Should be up before the end of the week. And one real quick question. If we didn't get to someone's questions, can they email those questions to this email address?
Yes, absolutely.
Okay.
Subject to my lawyerly instructions about just as if you were talking in public, right?
All right. Well, gentlemen, thank you. And everyone, thanks for joining us. We'll keep you posted on what's in store for the June continuing education series webinar. So we'll see you then.
Thank
Super
you.
good.
Thanks,
Thanks,
everyone.
guys.